Good afternoon, and thank you for joining us for the last presentation in our Brown Bag webinar series. We've saved the best for last. My name is Julia Love, and I'm a partner in our Employee Benefits and Executive Compensation Practice Group, and I'm pleased to introduce Brian Lamb, a partner and practice group leader of our Business Litigation Group. Brian has particular expertise with respect to ERISA litigation, and I'm really looking forward to his presentation this afternoon. During the webinar, please feel free to use the question panel at the upper right-hand corner of your screen to submit questions. We will answer questions at the end of the webinar as time allows. Any questions we do not answer during our time together today will be responded to via email after the webinar. Also note that there are two attachments available to you. One is a copy of today's presentation. The other is an affirmation form you can complete and remit in order to receive CLE or HRCI credit. We will go over the CLE form again at the end of today's presentation. And with that, I'll turn it over to Brian.
Thank you, Julia. Brian Lamb here. So I'm a litigator. I'll make that disclosure up front. So everything you're going to hear today is from the perspective of a litigator. I'm going to do this in two parts. First, give you a quick update on the state of ERISA litigation. And then the heart of the matter will be the second part, discussing my top 10 takeaways for fiduciaries and those who serve fiduciaries on how to avoid litigation, or if you're in it, how to win your litigation. So with that, my main way to set the table here is to point out that ERISA litigation is skyrocketing. In 2017, there were over $1 billion of settlements in ERISA cases, and I think we're on pace to have even more in 2018. We've had a number of big publicly announced settlements of ERISA cases. Deutsche Bank settled a case for $21.3 million recently. The University of Chicago settled for $6.5 million. There is just a lot of litigation going on. We will talk now about some of the types of ERISA litigation, what's hot and what's not. First, the employer stock litigation. This is actually not that hot right now. It's kind of cooled off since 2014 when the Supreme Court issued its opinion in Dudenhofer, which set a very high standard of pleading for a plaintiff to assert a claim based on the presence of employer stock in a 401k plan. And in fact, I think it's safe to say that not a single case that's been filed has survived a motion to dismiss since that standard has taken effect. That doesn't stop the plaintiff's lawyers from continuing to file employer stock cases. There are two varieties or two twists in the employer stock cases that were going on this summer. One is that the plaintiff's lawyers are starting to couch these claims as a breach of the duty of loyalty claims, in addition to the standard breach of the duty of prudence claims. And so far, courts have not been welcoming to this twist in the plaintiff's pleading efforts. One court said that the Dudenhofer standard, which was set in the course of a prudence claim, also applies to a duty of loyalty claim when it involves employer stock. Another court said, well, maybe it doesn't technically apply, but the reasoning behind it does apply. So for purposes of setting the table for my takeaways here, you should know that employer stock cases continue to be filed and the plaintiffs continue to lose them. Probably the hottest area is the fee litigation. These are cases in which plaintiffs are challenging the reasonableness of the fees paid by 401k plans or 403b plans on the public sector side. The fees that are paid using plan assets to third-party providers. These cases are super hot, super hot. Cases are being filed every week. Decisions are coming out seemingly every day. And just when you think a trend is developing in favor of the plaintiffs or in favor of the defense side, another case or ruling comes out which changes the way you look at it. So I would say my takeaway as a litigator is these fee cases right now are like two heavyweight boxers still slugging it out. The plaintiff's bar is morphing. Their tactics are morphing. They adapt to recent failures and try to get around them with the next case. And the defense bar is rallying every argument in the arsenal to try to fend these off. It is still the case, though, that the plaintiffs win some and they lose some, and there are mixed rulings that come out, which is pretty regular at this point, that a court will grant a motion to dismiss of counts 1 and 3, but leave counts 2 and 4 to continue on. And of course, in an ERISA case, a case that gets past a motion to dismiss is a very expensive case. Usually there's a lot of money involved and a lot of complexity and expert witnesses. So really that initial hurdle of getting past motion to dismiss is what the plaintiff's bar is looking for in the first instance. A sort of a subset of the fee litigation are the proprietary fund cases. This is where financial institutions are both the plan sponsor for their own company 401k plan, and they offer one or more of their own proprietary investment options, like a mutual fund, a branded mutual fund, as an option for the plan to invest in. These cases are also very hot, and there were some high-profile cases that came out just in the month of August. Wells Fargo won a high-profile case in the Eighth Circuit out of Minnesota, in which the Eighth Circuit upheld the dismissal of a proprietary fund complaint, holding that it was trying to essentially saying the plaintiffs were pretty much complaining after the fact that the Wells Fargo funds didn't perform as well as some other funds, and that's not enough to withstand a motion to dismiss. And then shortly thereafter, the T. Rowe Price case came out, in which a court held that the plaintiffs pled sufficient facts to allow the case to get past the motion to dismiss phase. And the court held that a complaint that specifically alleged the T. Rowe Price funds cost this much and had this kind of a historical track record compared unfavorably to certain reasonable benchmarks, which they specified in the complaint. If only they had invested in this other thing, which was more reasonable and which cost less, the plan participants would have been better off. And without really addressing the Wells Fargo case, the court said, yeah, that's sufficient to withstand a motion to dismiss. So you sort of have these two high-profile cases. One gets past a motion to dismiss, one does not. So I think these proprietary fund cases are going to be around for a while. It's true that every once in a while you see an article that comes out that says, is fee litigation in for a Dudenhofer moment? Like, when is the Supreme Court going to step in and pronounce something, a heightened pleading standard or a lower pleading standard, something that would give some clarity to these cases now, which are just really, I think, running amok. I mean, litigators are doing what litigators do and fight about ambiguities. Another subset of the fee litigation are the robo-advisor cases. A handful have been filed. If you don't know, robo-advisors is a shorthand term for companies that offer investment algorithms that help plan participants decide what to do with their investment funds. And it's not so much the algorithm which is being challenged in these cases, it's the method by which the robo-advisors are being paid. It all comes down to, are the fiduciaries paying reasonable fees out using plan assets? These cases are pretty early on, and I think we will continue to see them grow as the use of investment algorithms grows. And then there's litigation with other service providers, and we will talk about this because this is an important area for fiduciaries to understand, and I sometimes feel like they don't really. This isn't on their radar screen, but the question of whether a service provider who is providing some sort of services to a plan. Whether that service provider is itself a fiduciary is an important question, and we're going to get into that a little bit. So that's a quick overview of what's going on with the 401k and 403b type litigation, which begs the question, why so much litigation? And this is my view, again, as a litigator. It's money plus tension. The money factor, there's so much money held in 401k plans and 403b plans in the United States. And as the stock market grows, so does the value of these plan assets. The number as of the first quarter of this year, one estimate was $5.3 trillion in assets. That's just in 401k plans in the U.S. And you can tell my predisposition, but where there's money, you will find the plaintiff's lawyers take an interest. They went from tobacco, asbestos, breast implants. What's the next big thing? And for some time, the next big thing has been ERISA and ERISA plans. And it looked like it was going to be employer stock that was going to carry the day for the plaintiff's lawyers. And they certainly do win some, and they've gotten some settlements. But I think the fee cases really have the potential to be much bigger because every plan pays fees. And many times those fees are opaque and complex and cross-subsidized and hidden and difficult to ferret out, and requires expertise to do so. And the plaintiff's lawyers are investing heavily in the expertise to go dig in to the plan's expenditures of fees to see if they're reasonable. And what do I mean by ERISA's inherent tensions? Essentially, just think about how complex the goal of ERISA is, to bring uniformity to the world of employee benefit plans. Look at all these different constituents or people who have an interest in 401k plans, 403b plans, and they're all different, and they're in tension with each other. So you have this toxic mix of money plus people with different goals and incentives, and now you have an organized plaintiffs bar which is trying to make the most of it. I will add there's really a third reason. I could have included a third slide, and that is ERISA's inherent ambiguities or gaps. For litigators, there's two kinds of things that we litigate about: standards or rules. Okay, and a standard is something like you must stop a reasonable distance before the railroad tracks. Okay, that reasonable distance is a standard. It's not a measurement. An actual rule would be thou shalt stop at least 25 feet from the railroad tracks. It's more specific. It's easily understood at the time. It doesn't depend whether it's day or night or whether it's raining or snowy or slippery. 25 feet, go an inch beyond that, and you could get a ticket. So that's a rule. But a standard is thou shalt stop with a reasonable distance from the railroad tracks is subject to lots of ambiguity and debate. And in many ways, reasonableness is in the eye of the beholder. So you couple that with all these tensions and the amount of money at stake, and you think, what are the provisions of ERISA that are being litigated the most? Reasonable fees, or its corollary, excessive fees. ERISA doesn't provide a standard that says fees cannot exceed 0.005% of something. Instead, ERISA says thou shalt not pay unreasonable fees. So you have a lot of the ingredients for litigation here, and it's bad news for fiduciaries and employers. It's great news for litigators, and I do try to convert some of this bad news into positives by sharing with you some of my takeaways as a litigator like what's a fiduciary to do? Okay, so picture that you have been asked to serve in a fiduciary capacity for an ERISA plan. You're the HR director, and your boss says, "Hey, I want you to serve on the fiduciary committee for the 401k plan. Congratulations," or you're someone who provides service to that committee, whether it's a lawyer or an accountant or an actuary or a record keeper or whatever. What I'm going to say here today, while it's geared towards the fiduciary, it's very helpful, I think, or hope, for those who serve fiduciaries to also understand where a litigator is coming from in addressing, what to do about all this ERISA litigation. First, I looked it up, actually. The word fiduciary comes from the Latin phrase for trust, okay? And it's really a good way to, before we get into the top 10, to sort of think about it. You've been asked to serve as a fiduciary. You've been entrusted with a position in which you're supposed to look out for someone else's interests and not your own. And then broken trust, I think, is Latin for defendant. I can't tell if anyone's laughing in the audience, but right. Yes, if you're a fiduciary and the first thing you need to be aware of is you have this great responsibility, but with it comes potential liability. So my takeaway number one as a litigator is for everyone who acts as a fiduciary or who advises fiduciaries to take a sober moment and reflect on the fact that under ERISA, liability is personal, okay? So any fiduciary who breaches their obligations shall be personally liable to make good to such plan any losses to the plan resulting from each such breach. And further down in the statute, there's a specific reference that says a fiduciary may also be removed for a violation of section blah, blah, blah. So, and I think this sometimes gets lost on corporate America, people who are asked to serve on fiduciary committees, which is certainly, I think, a majority of the fiduciary setups in corporate America involve a committee of people who are entrusted with fiduciary duties. It's very important for each committee member to understand that they are individually a fiduciary. Okay, they may not be able to act alone for the plan. They're just one of a deliberative body. But the same is true for the board of directors. Each director is individually a fiduciary under state law, but most directors don't have the power to do anything alone. They can only act as a part of a deliberative body. But it would be a grave mistake for a corporate director to say, well, I don't personally have a fiduciary duty. That's just when we get together as a group. The group has a duty. And the answer to that is no, that's not the case. You, the board member, have a direct fiduciary duty, a personal fiduciary duty, and you, the ERISA fiduciary, have a personal fiduciary duty. This was highlighted in the recent NYU case, which was the first 403B excessive fee case to go to trial this spring, and the ruling came out this summer. And while NYU, as defendant, got a complete defense verdict from the bench, along the way, the court, the plaintiff's lawyers, and the court made many critical comments about individual committee members and how they did or did not view and or discharge their duties. And one committee member, the committee was the fiduciary, and one committee member who was an employee of NYU testified, well, I'm not a fiduciary, the committee is a fiduciary. And the court went to great lengths to point this out in her ruling, that you can't look at it that way. Your liability under ERISA is personal. And the court, by the way, went through and critiqued the performance of not every, but some of the individual committee members, one who stood out for commendation and a couple who stood out for criticism. So given that liability is personal, how does this affect you? Well, consider your performance as a fiduciary or committee member being talked about in the press. Here's just one of many articles that were coming out during the NYU trial. And I'll talk a lot about the NYU trial today because it's so unusual for an ERISA case to go all the way through trial. So we got a peek at the deposition testimony, we got a peek at courtroom testimony, and then the court issued a lengthy opinion with findings of fact and conclusions of law. So we got a real glimpse inside how NYU's 403B committees operated, and some of it wasn't pretty to look at. And after the closing arguments, many people, including me, thought for sure that NYU was going to lose because the judge was so critical of some of the participants on the committee. When the ruling came out, it actually was in favor of NYU, and the court did say, as a whole, the committee discharged its duties, but she had very unflattering things to say about some of the committee members. But so you're the fiduciary or you're the advisor. Picture your conduct being scrutinized in the press, or worse, picture it being the subject of pleadings in federal court, which are publicly available. At the end of the NYU case, although the plaintiffs lost, I think they were trying to find a way to justify legal fees, so they filed a motion to remove two of the individuals who served on the fiduciary committee. So think about it. The NYU, the defendant, won, and the court said, as a committee, you discharged your fiduciary duties. Yet the plaintiff's lawyers is now going back through the record and through the rulings and saying that the judge criticized these individual committee members. And so they have filed this motion, which is still pending. And but it's a sober moment for individual committee members and their advisors to look at this and say, that could be my name up there someday. So how do I want to be viewed? How do I want to conduct myself to insulate myself as much as possible from these kinds of ramifications? Now, I will say there's a little bit, the empire is starting to strike back, and a federal judge in the Cornell University case was faced with a motion in which the plaintiffs wanted to amend their complaint, which is usually a very easy thing to convince a judge to let you do. I've got a complaint, things have changed, I want to amend it. The rules are set up to sort of favor that. But what they wanted to do was amend the complaint to add 29 individual Cornell University employees as defendants in the case. Okay, and this has been part of the plaintiff's playbook for a while. Let's sue the board of directors. Let's sue all these people individually. Let's go after these two people and try to get them removed. They know it's a pressure point. They know that a corporation or a university is sort of this amorphous entity, but things become real when individuals' names and reputations are at stake. Well, the judge in Cornell, rather than just granting it as a matter of routine, actually wrote an order and said to the plaintiffs that you shall address why you need to name 29 individuals as defendants, other than A, you think you can, and B, the assertion of multi-million-dollar claims against these individuals who served on a committee at their employer's request has the tremendous power to harass these individuals because they will be required to list the lawsuit on every auto, mortgage, or student financial aid application they file. Is there any meaningful relief that could not be obtained without naming these individuals? This is a federal judge pushing back on the plaintiffs for this technique earlier this year, and it was cited by the defense in the NYU case as, stop these plaintiffs' lawyers from picking on individuals. But it's still a lesson to be learned for those of you who are serving as or for fiduciaries. Your personal reputation is at stake. Next, number 2, this actually shouldn't have to be said, but it does. Read the plan documents. Read the plan documents. You know, if you're a judge, you should read the U.S. Constitution. You would hate someday to have someone ask you if you've ever read it and admit, I've never read the Constitution. If you're a judge, if you're a federal judge, say, okay? If you're about to sign a contract as a party and a dispute comes up later, you don't want to be the one in a position of saying, I didn't read the contract, okay? There are certain fundamental intrinsic documents that certain people with certain roles must read. And the plan documents for an employee, for a retirement plan or any employee benefit plan, it's a must read. ERISA has its requirement that there be a written plan document, and it really does serve as the touchstone for most of the responsibilities. You know, thou shalt act consistent with the written terms of the plan. It's a very, very fundamental point. Well, in the NYU case, a member of the Fiduciary Committee admitted under oath, I don't review the plan documents. That's what I have staff for, okay? And at some level, you sympathize with the sentiment. It's like the plan document is probably 112 pages long. It's full of legalese and boilerplate and acronyms and, you know, things. It's very dense and difficult to read. But this was a very bad moment for the defense in the NYU case, that a fiduciary has to admit, I don't review the plan documents. And the judge was concerned about it, criticized the committee member for lack of familiarity with basic concepts relating to the plan. And then guess what? You'll never get the benefit of the doubt either. You admitted you didn't read the plan document. Like, you still want to fight in litigation about the proper interpretation of it, or that you ought to be held to have followed it when you didn't read it. It just hurts it hurts the optics of your case, you know, and I think also the merits of your case. So it's a process point, you know, in some ways. Read the plan documents. Not everybody is going to understand every provision in the entire plan document. But if you don't understand it, think about the poor participants, and you're their fiduciary, you're their stand-in. And again, I think a judge would be sympathetic with, you don't understand the complex interplay of Section 12A and Section 17B Romanet 2. Like, yeah, there's an interpretation problem here. But if you start off the discussion by saying, I've never read the plan document, I rely on others for that, it's an unforced error, okay? So hopefully there'll be a lot of people on the webinar who run back and read plan documents now right after this. It really is a thing that I think the plaintiff's counsel perhaps caught this person unawares, and I guarantee that by the time of trial, after her deposition, by the time of trial, that she had read the plan document in case she was asked again in court. I mean, that's what I would expect as a litigator. But you want to have this orientation from the get-go. Read the plan documents. Okay. Number 3, don't be a clock watcher. Okay. This was a really, really memorable part of the plaintiff's closing argument in the NYU case. Okay. Their theme was that basically the plaintiff's theme was all these people at NYU who served on the committee were too busy to do a good job. Too busy to do a good job. They were distracted. They had other things going on, and they were able to, paint this picture. Judge, they're too busy. It's one of those committees where they meet at 4:30 in the afternoon on a Friday, and everyone's checking their watches. Like, that's kind of unverifiable, except maybe with the time of the meetings. But were people really checking their watches? But this is a lawyer's rhetorical flourish to paint a picture for a judge, which they then support with some of the things that we'll see next. Like, what do you mean? But it just really drives home a theme: too busy to do a good job, careless, too busy, not paying attention, wasn't a priority. This wasn't a priority to them, Judge, and they were fiduciaries. And, fiduciary comes from the Latin for trust, and they were too busy looking at their watches. So in this regard, it's important to show up for meetings on time and to stay for the entire meeting. We can see now from these cases that the plaintiff's lawyers are reviewing the minutes of committee meetings with a fine-tooth comb, searching for signs of poor attendance, in and out, who's the person who always asks to be patched in by phone even though they're right down the hall. The plaintiff's lawyer will then build a case that these people lack the care and diligence of prudent fiduciaries. It's, a minute here on minutes. I'm often asked, like, how much is too much to put into the minutes? I can tell you that if you don't put it in the minutes, first of all, memories fade and people will forget. But the plaintiff's lawyers will start with the premise it didn't happen. It wasn't even referenced in the minutes. It didn't happen. It doesn't mean it actually didn't happen or that a judge won't believe credible testimony. But it's a process point that if something important is going on, it ought to be referenced in some way in the minutes. As a litigator, I don't recommend trying to do a transcript of the meeting either, because that is messy and leads down a lot of rabbit holes in depositions later on. It's try to find the right balance. But for purposes of not being a clock watcher, you have to show up at the meeting and you have to pay attention before you can be worried about what's in the minutes. Also, don't be a paper pusher. The judge in NYU criticized a member of the committee for viewing paper movement as her primary function. And again, another unfortunate phrase that came out of somebody's mouth, or that the plaintiff's lawyer got somebody to testify to. But it's not a good look. And while process is important and moving paper is certainly part of the story, it can't be the end all and be all. There must be substance behind your process. And lastly, on this point, don't be a distracted driver. In NYU, one of the committee members testified, why didn't you do something? And she said, I have a big job, referring to her day job, not to her fiduciary role. And again, this played into the plaintiff's theme, that she was too busy to be a good fiduciary. The judge criticized the individual as displaying a lack of true appreciation for the significance of her role as a fiduciary. I mean, if there's one thing that my 10 takeaways add up to, it's like, have a true appreciation for the significance of your role as a fiduciary or as an advisor to a fiduciary. Next, consult qualified experts. This expert certainly looks qualified. He's got the glasses and the bow tie and is reading. A few words on experts. Not every individual who serves on a committee is going to have all of the subject matter expertise that's needed. And that's why a committee is stronger than one individual. But sometimes the committee as a group won't have the expertise. In my view, the outcome in the NYU trial completely hinged on the court's assessment of the credibility and qualifications of the experts that had been retained by the fiduciary committee to help advise them on plan matters. The judge went out of her way to minimize the testimony of the trial experts that the plaintiffs hired, and went out of her way to praise the qualifications and dignity and sobriety of the experts who not only helped advise the committee historically, but who then appeared at trial and explained what they did. And I think many people agree with me that strong experts led to a defense verdict in that case. But just hiring experts is not enough. Okay, you really have to pressure test the experts' advice because experts don't know everything. They don't know your plan as well as you do. They don't know your company or your business. They don't know your employees. You are closer to many things than experts are. So you have to figure out the right way to get and use the expert's advice. Okay. These are recent ERISA fee cases are showing that fiduciaries may rely on experts, but they may not unthinkingly defer to experts' opinions. Okay, so think about that. It's a fine line. You don't have the expertise yourself, so you go out and hire it, and you can rely on them, but you can't completely defer to them. Okay, and the way I look at this is that being a fiduciary is like being a parent of a child. Okay, so I'm not a doctor, but if one of my kids gets sick or has an ailment, it's my job to go find the right doctor. Are we going to the pediatrician, or are we going to the brain surgeon? I'm responsible for picking the expert. I then go with my child to the appointment. I watch what the expert does. And if my child is complaining of an earache and the expert's advice is to amputate the left foot, it's my job as a parent to say, wait a minute, what does that have to do with an earache? What are you doing? And you may need a second opinion, but you may need to, what you really need to do is ask questions like why, what's the relationship between the ear and the foot? And then you judge the credibility of the answer that they give you. And in fact, actually, I know under Ohio law, a parent is actually a fiduciary. So these are fiduciary principles. And I think for me, this has been a helpful way to understand what you're supposed to do when you're not an investment expert and someone's talking to you about rates of return and things that aren't really part of your day job. How do you deal with it? Well, don't just let go and let be. Instead, as the court in NYU put it, kick the tires. She literally said, good old-fashioned kicking of the tires of the expert's work is what's required. Okay, so meaningfully probe the expert's advice. That the court actually singled out for praise one committee member who quote questioned the expert's recommendations all the time. I mean, that as a litigator, that is just great. You like to see there was somebody on that fiduciary committee who questioned what the experts were doing and recommending. And it came out in her deposition, and other people verified it. And while some people said they viewed themselves as paper pushers, so one of them said, I viewed it my job to ask questions. So at the end of the NYU case, the court said between the consultant's advice and the guidance of the more well-equipped committee members, which is a backhanded compliment to the less well-equipped committee members, the court is persuaded that the committee performed its role adequately. So that's a C-. It's a passing grade, but barely. You can see with hindsight how they could have gotten a much better grade. They did get a passing grade, but they took some bumps and bruises along the way. Or I guess, as my son says, C's get degrees. So they got a C and they got their degree. But we should be aiming for A's at all times. Okay, let's switch gears over to engaging service providers. First and foremost, for the fiduciaries, both the selection and the retention of service providers are fiduciary acts. Okay, so when you go hire a record keeper, when you go hire a robo-advisor, when you go hire an actuary, the act of you selecting and retaining that service provider are fiduciary acts. In other words, you must act with care, you must act reasonably, you must act not with self-interest, but solely with an eye towards the interests of the participants. You can't look at it like, oh, I'll pick someone and then it'll be their problem to deal with. It'll be their job to be the fiduciary. No, your selection, just like my picking and deciding which doctor to take my sick child to, that's a fiduciary act, which could be questioned if I take him to the wrong kind of doctor, that people later would say, why would you do that? Why would you go to that doctor? Okay, so just take care when you are selecting people, service providers, you are a fiduciary doing so. And notice this applies also to retention, which means not the actual engagement letter, but every day thereafter, you have a duty to monitor the service providers. It is a fiduciary job you have to monitor how they are doing. And if you mess it up, you can be liable. So the plaintiffs try to argue that, for one thing, they're trying to bring the board of directors into a lot of these cases now, arguing that it's the board that usually selects and retains the fiduciary committee within a corporate structure. And so the board members acted in a fiduciary manner by selecting, who the other fiduciaries would be. And then the plaintiffs take it a step further and they say that the appointing fiduciary is liable for all of the screw-ups of the service provider that's been hired. And as a defense-minded person, I say the answer is no, and many courts agree with me. Your job is not to do over the job of the expert that you hired, or to quibble with whether it's 0.001% or 0.0015%. It's instead to monitor them in a prudent way, like the parent monitoring the doctor. So if I pick a bad doctor and she screws up, I may be liable. I screwed up in picking the doctor. But if I picked a good doctor who, unbeknownst to me, showed up drunk for the surgery and ruined it, I can't be blamed for that, because I would say this doctor was highly rated and came recommended and works at a world-class institution. I didn't know about the drinking problem. Okay, so but the plaintiff's lawyers don't like these nuances. They're expanding, this to try to bootstrap anyone who appoints someone to be the guarantor of their duties. It's just one of the beautiful complexities of ERISA. When you are the service provider who's being engaged, ERISA's usual functional test applies to determine whether you're a fiduciary or not. And contrary to what many people think, just writing in the agreement, "I am not a fiduciary," does not control, and does not mean a court will agree with you later on. The words do not control. The question is, did you function as a fiduciary? These are very, interesting cases going on these days, whether a service provider is a fiduciary when negotiating their own fees. Because in a sense, you're taking plan assets, and but courts say that the act of negotiating for future fees, you're negotiating with a fiduciary who has to protect the plan assets, but you, the service provider, are not acting as a fiduciary. You're allowed to look out for your own interests to strike the best deal you can prospectively, okay? But if you can set your own fees or decide how much to take after you've been engaged, then you will be squarely in the crosshairs of the plaintiff's lawyers, who argue you have now become a fiduciary because you have discretionary control or influence over plan assets. And it's true that there are cases that say the more discretion you have, the more likely it is that you will be treated as a fiduciary, which means you're subject to all of ERISA's fiduciary duties. The really interesting case came out earlier this week on Tuesday, in which Principal Life Insurance Company won summary judgment in a case where they offered guaranteed investments to a 401k plan, and they set the prospective interest rates for each guaranteed fixed income contract. They set them prospectively, or in advance, for the next 6 months. But then 6 months from now, they set the interest rate for the next 6 months. And in doing so, by affecting the interest rate, they were actually affecting how much of the spread on the returns they would get to keep themselves. So the plaintiff's lawyers said, well, you're engaged and you have discretion over your own fees. Therefore, you're a fiduciary. And I think your fees were too high and you didn't disclose this and that, all the fiduciary standards. And the court went through a detailed analysis of these cases and ultimately concluded that because the participants could vote with their feet, as the court said, and that is, they could withdraw their money virtually without penalty every 6 months if they didn't like the new interest rate that was being offered. So Principal would say, for the next 6 months, here's the interest rate. And if you don't like it, you've got 30 days to pull your money out. And the court said, that's just Principal fulfilling a contract that was already agreed to. It's not them forcing participants to act in a way to generate certain fees. But anyway, so these cases are very much live and active right now. Good news for lawyers and accountants. If you're acting as a lawyer or accountant doing your usual professional function, you will not be treated as a fiduciary. But if you transcend the usual scope of services, you will be treated as a fiduciary. So you see the kind of phrases, the attorney crossed the line and did more than what a usual attorney does, or the accountant exercised judgment over plan assets. They weren't just acting as a bookkeeper. Typically these cases involve a lawyer or an accountant actually directing where the assets are going to go or siphoning some of them off. And they don't get the benefit of saying, I wasn't a fiduciary. Like they could go so far as to act as a fiduciary and therefore be subject to ERISA standards. Number 7, again, this is nowhere in ERISA does it say thou shalt conduct periodic RFPs, but it is a frequent refrain of the plaintiff's lawyers in these fee cases that once you find experts that you like a lot, you shouldn't use experts you don't like a lot. Then once you start relying on them, but not too much, right? You can't unthinkingly rely on them. Now you got to consider replacing them every few years. Like what? We just found the right perfect person or the perfect company. They know our business. They're fully entrenched and ingrained. And it'd be so disruptive and burdensome to move. Like, why do we have to do an RFP? And the plaintiffs can put on a very convincing case that an RFP process can result in lower fees, better service, and a good night's sleep for the fiduciary committee, knowing they've canvassed the market for the right mix of quality and cost for the benefit of the plan. With record-keeping RFPs are the ones plaintiffs, start with the most. And they make these arguments, I think, which have some merit, that just out in the real world, new clients usually get special attention and discounts. Old clients get treated like old slippers, and they don't get the latest discounts or special introductory offers. So an RFP can sort of switch that around by putting the service provider back on their toes and treating you like a new client, like you're one who's going to re-up with us. Benchmarking certainly helps ensure the reasonableness of fees. And all these fee cases talk about benchmarking, and the plaintiff's lawyers cherry pick the unfavorable benchmarks. The defense lawyers cherry pick the favorable ones. As the fiduciary, from a process perspective, you want to say, I did it. I benchmarked. In some ways, the actual results of the benchmarks are going to fall in a gray area subject to your judgment. But if you didn't do the benchmarking, it's hard for you to argue later on, hey, well, my fees fell within a reasonable range. Well, yeah, by luck they did, maybe, but I kind of believe this other expert, and I'll never know because you didn't go create a paper trail at the time. Plaintiffs argue that record keepers specialize in market segments, and your market segment might change because you merged with somebody. This last one I've heard, I don't know if there's any scientific proof, but if there's no auto enrollment for a plan, an RFP can generate interest. I guess particularly if you actually pick a new provider as a result of it. Now there's going to be communications, and I think if you probably re-up with your existing provider, which is certainly reasonable, maybe this last bullet point doesn't really apply. People frequently ask, how frequently are we required to do an RFP? And ERISA doesn't answer the question, and litigation is not optimal for such things. But there does seem to be some coalescence around this about once every 3 year standard that came up in this Kraft Foods case. The district court had granted summary judgment to the fiduciary, arguing that their record-keeping fees were reasonable. The fees they had paid were reasonable, and that they had consultants who told them so. Great, summary judgment granted to the defendant. Well, on appeal, the Court of Appeals said, well, wait a minute. The plaintiff said that there's extra benefit just from soliciting competitive bids, and that a reasonable fiduciary or prudent one would do that about once every 3 years. So the Court of Appeals reversed summary judgment, took away the defendant's win, and said go back and have further proceedings on the question of how frequently someone ought to have done RFPs. So, again, I'm not saying you have to do them every 3 years. I am saying from a litigator's perspective, it would be nice if I could defend you by proving that you had done competitive RFPs about every 3 years. Well, number 8 is beware the defaults of others. In many facets of life, we focus on our own conduct and worry about our own business. Sadly, ERISA does not allow us to do that because it has a particularly harsh, even cruel and unusual, I would argue, scheme of co-fiduciary liability, which can make one fiduciary 100% liable for the wrongful acts or omissions of other fiduciaries. Okay, you could have done everything you wanted to correctly, but someone else screwed up. So when can you be liable for others' faults? You can be jointly and severally liable, which is legalese for even if you're 1% responsible, you may have to pay 100% of the damages. You can be responsible for breaches where where you knowingly participated in the other's breach, you knowingly concealed the other's breach, you enabled the other's breach, or this one is the one that trips people up. You have knowledge of another's breach and you did not make reasonable efforts to remedy the breach. You cannot put your head in the sand. So if you're concerned that someone else is not meeting their duties, you must not look the other way. You have an affirmative duty to protect yourself and the participants, or face liability as if you were liable yourself. 9, your continuing duty to monitor plan investments. The Supreme Court made clear that the duty of prudence involves a continuing duty to monitor. That much was clear, I'll say. What that exactly means, particularly for statute of limitations purposes, but also just for your daily duties, very much subject to litigation. But the idea is you cannot be like this autopilot and set it and forget it, okay? You have a continuing duty. Once you go through all the hard work of making a difficult decision, now you have to monitor how it's going. And then lastly, my one thing that's obvious from all these slides, if you've been asked to serve as a fiduciary, ask about fiduciary insurance, okay? There's a real misconception out there that D&O liability policies will be sufficient to cover you if you're an employee of the company that has a D&O policy, that it will protect you from your service as an ERISA fiduciary. And the truth is the opposite. Most D&O liability policies do not include service as an ERISA fiduciary, and therefore most employers are getting separate riders or separate policies specifically designed to cover fiduciary liability. Huge companies with big insurance departments are usually on top of this. Medium-sized companies that work with outside brokers usually are getting good advice about this. Smaller companies tend to not get great advice and may simply rely on their D&O policy, and it's a big mistake. And as I made clear in slide number 1, you could have personal financial liability for your service as a fiduciary, so you have every right to ask, am I insured for this, what you're asking me to do. Keep in mind, this is different from a fidelity bond. It's fidelity insurance, which protects you. The fidelity bond protects the plan. And I would recommend that you get advice from a broker or lawyer who can help you with the other questions that come up. Can my employer indemnify me? Can the plan indemnify me? Who pays for the insurance? There's lots of questions, and ERISA answers some of those. The DOL has views, and you do need guidance. In summary, then, these are the 10 takeaways that we've discussed here. And I do think they all come down to that one quote we heard from the NYU judge, which is, please have an appreciation for the significance of the responsibility that you've agreed to undertake. That's really what it is. Like, take the job seriously, make time for it, make it a priority, get the right advice, treat the plan like it was your child, care for it in that manner, and hopefully you'll avoid litigation.
Thanks, Brian. We will begin the Q&A session in just a minute. However, I'd like to remind you that if you would like CLE or HRCI, please note the attachment on the right side of your screen, above the screen where you type in your questions. You will need to print, complete, and submit the attorney affirmation form to receive credit. You will need to include the code on the form. The code is TH, as in Thompson Hine, 927. Also attached are slides from today's presentation if you would like to keep them for your future reference. After today's session, you will receive via email a very brief summary regarding the webinar. This survey will only take a few minutes to complete, and we would appreciate your feedback on the presentation and how we may serve you in the future. Now let's move into the Q&A session. Please type your questions in the question box. We will address them as they come up with the time remaining. And Brian, while we wait for our attendees to ask some questions, going back to all the slides that you had about the NYU case, one thing that comes to my mind is, how do you determine who are the right people to serve on your committee? Clients often ask me, do we want the top named executive officers of the company to serve on the committee? And I always say, no, because we don't want them in deposition saying, I didn't have time to look at the plan document or whatever, and they have other important things to do. So who are the right people for the committees? So
first of all, I do agree that board members and usually C-level officers should try to avoid being involved in the day-to-day fiduciary committees for the reasons you've expressed. They have so many other things going on. You don't want a record in the minutes that they're absent from 3/4 of the meetings. And you also just don't want to put them, they have other things to do. So my view from a litigation perspective, the best committee is one that is well-rounded. So it's got the HR perspective, it's got the maybe the information perspective, it's got the finance perspective, investment expertise, and there's probably not a single person who has all those different things. That's why you want a committee. So I think it is great when it's like the head of global benefits and the head of HR and the vice president of information technology, where people sort of at that level are the ones who are. It shows that the company treats this seriously, and we are putting in people that have busy jobs, in these roles, but it has to be made clear to them and to their bosses that this is a serious priority of theirs, and it can't be pushed to the bottom of the pile.
Right. Another question that I had relates to the payment of fiduciary expenses or plan administration expenses from plan assets and who can approve those. So in a situation where you have a co-fiduciary, who's also providing services to the plan, clearly we don't want them approving their own invoices. So what's a standard process to approve payment of expenses from plan assets?
Well, you definitely, from a litigation perspective, you definitely want someone other than the recipient of the fees to be scrutinizing the bills, making sure they're consistent with the contract arrangement for what's supposed to be paid, and making sure that the services were actually provided to justify it. Like, all that would go into what's a reasonable amount. And it actually just sort of goes without saying that the recipient of those funds cannot be the one approving their own bills. I think the actual process would depend on your charter and your governance documents.
Okay, I see we're at 12:59. We haven't received any questions from. Oh, can you please repeat the code? Yes.
Oh.
TH as in Thompson Hine 927.
TH 927.
Yep. Otherwise, we haven't received any questions.
Great.
So I will thank Brian and everyone for attending this afternoon and for attending our entire webinar series. As a reminder, please complete the survey that you received via email. And if you have any other questions about getting CLE credit or HRCI or whatever it was, credit, feel free to email us. And the slides are available on the webinar screen, or if you need copies of the slides, let us know as well, and we'll email them to you. Thank you very much.
Thank you.